Our greatest weakness lies in giving up. The most certain way to succeed is always to try just one more time. Welcome back, my UPSC warriors. Session 2 down and the legal gears are turning. Today, we are taking things a step further. We are not just studying the law, we are becoming the judges. Remember, the UPSC Prelims are like a high stakes courtroom drama. You have analyzed the evidence, and now it's time to understand the judges who ensure justice prevails. But fear not, this is not a blindfolded leap of faith. We'll be dissecting the intricate structure of the Indian judiciary from the mighty Supreme Court to the grassroots district courts. Remember, every question conquered brings you closer to that coveted final verdict, UPSC victory. This session is not just about memorizing facts. It's about understanding the power dynamics at play. So, sharpen those analytical skills, embrace the critical thinking, and let's unlock the mysteries of the Indian judiciary together. This is a chance to truly grasp the gavel's significance and the role it plays in creating a just and equitable society. Now, gavel in hand, let's delve into the fascinating world of the Indian judiciary. First up, we have as I said earlier, the schedule for our entire target prelims program. This is the schedule. You can pause it and have a look at it, plan your revision accordingly. Let's begin. The first question. Consider the following statements. The number of judges in the Supreme Court can be increased by the Parliament by law. Number 2, the number of judges in the High Courts can be increased by the respective state legislatures by law. And number 3, in case a High Court serves 2 or more states, the number of judges in such High Courts is increased by the Parliament. So, the number of judges in the Supreme Court, of course, can be increased by the Parliament by law. This is Article 124, Clause 1. And what is this? The number of judges, of course, will be decided by the Parliament by law. Originally, we had the Chief Justice of India plus 7 Supreme Court judges. Now, we have CJI plus 33 Supreme Court judges, right? And at any point of time, if you want to increase the number of judges in the Supreme Court, you simply have to bring a bill to modify a law. And what is that law called? Supreme Court Number of Judges Act of the year 1956. That's it, right? So 1 is, of course, correct. Number 2, the number of judges in the High Courts can be increased by the President, okay? Not by the state legislature, but by the President. So, to increase the Supreme Court judges, legislative action, parliamentary intervention is required. To increase the High Court judges, executive action is required, right? So, currently we have 1,114 judges in the High Courts, or at least that's the total sanctioned strength. You will find this mentioned under 216, Article 216. So 2 is incorrect. And number 3, in case the High Court serves 2 or more states, it does not really matter. The number of judges in a High Court will always be decided by the President. So 3 is also wrong. How many statements are incorrect? B is the right answer, 2 only. Next question. Consider the following statements regarding the Collegium System for appointing judges in India. Collegium System, right? The Collegium to recommend names for Supreme Court judges comprises of CJI and 4 senior-most Supreme Court judges. Yes or no? Of course, yes. Absolutely correct. So see, the Collegium for Supreme Court judges appointment comprises of the CJI, 4 senior-most Supreme Court judges. The Collegium for recommending names for High Court judges, CJI plus 2 senior-most Supreme Court judges. And in case you want to transfer a judge from one High Court to the other High Court, then again we are back to the CJI plus 4 senior most Supreme Court judges. And we also take the opinion of the Chief Justices of the 2 High Courts involved. One High Court from where the judge is being taken out, and the other High Court where the judge is being put into, right? So that's there. Number 2, the CJI has a veto power. Yes, of course. Veto means to negate, to nullify. Yes. If at any point of time other judges agree, but the CJI says, no, I don't like this judge at all. I don't want to recommend his name. Maybe 20 years ago, he did not give me a pencil in my class, in my college days. That's it. If the CJI says no, your name will not be forwarded. Simple. Yes, CJI has a veto power. And number 3, the recommendations of the Collegium are binding on the President. No, they are not at all binding. In fact, there is no time frame fixed for the President to appoint, and also if any one judge of the Collegium disagrees with the name, then the government, the President, can send back the name as well. So this is wrong. 1 and 2 are correct. What's the right answer? How many statements are correct? 2 only. Now, next question. Consider the following statements regarding Court of Records in India. Court of Records, right? So, a court of record is a court whose proceedings are permanently recorded, making its judgments, proceedings, and acts official legal evidence. Absolutely correct. Court of Records means a court whose verdicts hold evidentiary value, whose judgments can be used as precedents by the lower courts. In our country, Supreme Court is a court of records under the provisions of Article 129. High courts are court of records under the provisions of Article 215. 1 is correct. Such courts also have the authority to punish for contempt of court. Yes, court of records always have this authority to punish for their contempt. Both statements are right. C is the right answer. Next question. Consider the following statements regarding the removal of judges of the Supreme Court of India. So, a Supreme Court judge can be removed from office only on the grounds of proved misbehavior or incapacity. Is that correct? Yes. 2 provisions deal with the removal of Supreme Court judges. 124 clause 4 and clause 5. This is absolutely correct. So there are 2 reasons or 2 grounds to remove the Supreme Court judge: proved misbehavior or incapacity. Now there is no definition of this in the Constitution. That is highly subjective. Number 2, the removal motion can be introduced in either House of Parliament. Yes, of course, that's correct. The only condition is that in the Lok Sabha, it would require 100 MPs. In the Rajya Sabha, it would require 50 MPs. Number 3, Parliament by law can provide for the manner, process in which the judges can be removed. Manner means the process. What process has to be followed to remove the judges of the Supreme Court? So yes, Parliament by law, Article 124, Clause 4 and 5 provide for this, and there is a law made, a very popular law called Judges Inquiry Act of the year 1968. 3 is correct. Number 4, no judge has been removed so far. Yes, so far we are yet to see the removal of any judge. We have seen lot of issues and concerns. Justice V. Ramaswamy 1990s, Soumitra Sen, P.D. Dinakaran. However, no judge has been removed by the Parliament so far. The process is so difficult, so complicated, so challenging that it's almost impossible to remove a judge. Anyway, so all the statements are correct. Right answer is D. All of the above. Next question. The Chief Justice of India is called the Master of the Roster because, so this roster is the what? The diary of the court. Think of it as the diary. Anyway, the Chief Justice is also known as the first among equals, and because of this, The CJI is responsible for the allocation of cases and the appointment of constitutional benches. So why is he called master of roster? Is because he or she allocates what case will go to which judge or which bench. So C is the right answer. In fact, back in 2018, there was a challenge made to this Shanti Bhushan case. However, nothing could come out of it because Supreme Court was adamant that no, CJI will hold this authority. Anyway, right answer is of course C. Next question, with reference to recusal of judges. Recusal of judges. Consider the following statements. As per the Judges Inquiry Act 1968, if a judge does not recuse himself or herself from a case involving conflict of interest, it can become one of the reasons for the removal of the judge in the parliament. There are only two reasons why a judge will be removed. One reason is proved misbehavior. The other reason is incapacity. Articles 124, clause 4 and clause 5. Clause 4 mentions this. That's it. No other reason, right? So this is wrong. Now, what is recusal? Having a prior or personal association with a party involved in the case can be a reason for recusal. Yes, that is what is recusal. Recusal means a judge takes back his name from the case, from the bench. He withdraws himself that no, I will not deal with this matter. I will not be a part of the bench. I will not give my verdict on this matter because I might have some kind of prior association, maybe a personal relationship, or maybe some kind of financial interest with either party involved. Let's say one party could be a very close friend, a party could be, let's say, a very hated enemy, etc. So if you have some prior involvement or association with any party, you recuse yourself. That is one reason for recusal. You know why? Because principles of natural justice have to be maintained always. It's very important. So 2 is right, 1 is wrong. Right answer, of course, B. 2 only. Next question. Which of the statements, following statements regarding judges of Supreme Court is incorrect? So we have to look into the incorrect statement. Okay. The senior most judge of the Supreme Court should be appointed to the office of CJI. That's correct. After the Collegium judgment, it has been made mandatory that the senior most Supreme Court judge, senior most not by age, but by experience in the Supreme Court. Whoever has served in the Supreme Court for the longest time, whoever gets elevated or appointed to Supreme Court earlier becomes a senior. Simple. So this is correct actually. We want to find out the incorrect one. Let's continue. It is mandatory for the President to consult Chief Justice of India during appointment of other Supreme Court judges. Yes, CJI is a part of the Collegium, every possible Collegium, whether for the High Court, Supreme Court transfers, plus CJI also has the veto power. So you have to be in the good books of the CJI. Keep on sending him good morning texts every day. I mean, you have to be in his good books. That's it. C. Constitution has prescribed 45 years as a minimum age for appointment as a judge. There is no minimum age to be appointed as a judge of Supreme Court. We do have a maximum age. So the age of superannuation is how much? 65 years. But there is no minimum age. C is the answer because we had to find out the incorrect statement. And D, only a citizen of India is eligible to become a judge of the Supreme Court. Absolutely correct, right? So yes, citizens of India can become judges of the Supreme Court. Correct statement. Next question. Which of the following statements are correct? The Constitution of India empowers the Supreme Court to entertain a petition as an appeal, even in cases where High Court declines to issue a certificate for that appeal. Okay. And special leave petition is a discretionary power of the Supreme Court and cannot be claimed as a matter of right. Whenever we have to appeal against a High Court judgment in the Supreme Court, you cannot simply walk into the Supreme Court and file a case, throw it come on, my lord, case. That's not how things are done, right? You don't have the right to approach Supreme Court every time. Sadly, that's not the case. You can only approach Supreme Court if it's a constitutional matter, Article 132, or it's a matter which is of larger public interest, a civil matter, Article 133, or if the High Court has reversed a lower court judgment and has given you at least 10 years of jail sentence, only then, or if the High Court, these are all articles, or if the High Court gives you the permission certificate of appeal in the Supreme Court. Now, beyond this also, Supreme Court may, in its own discretion, grant special leave. Special leave means special permission. SLP, special leave petition. So Supreme Court can grant special leave to appeal from any judgment or any sentence, etc., made by any court, any tribunal in the territory of India. So you can request the Supreme Court that, my lords, lower courts are not giving me any certificate. My case is not that big, but somehow I feel it's very important, right? So please allow me to file a case. Now, Supreme Court may do it. Special leave petition is a discretionary power. You cannot claim it as a matter of right that, no, I deserve it. Sorry, you deserve nothing in the Supreme Court. Okay? So it all depends. Subjective opinion of the Supreme Court. So both the statements are correct. Article 136, this is nothing but Article 136, special leave petition. Right answer is D, both 1 and 2. Next question. Consider the following statements regarding the High Court judges. Okay. The High Court judges on retirement are debarred from practicing in the Supreme Court as an advocate. Is it true? Not really. Though for Supreme Court, we have a separate provision called Article 124, Clause 7, which says that whenever a Supreme Court judge or anyone who has served as a Supreme Court judge will not be allowed to plead or practice in any court of law within the territory of India. So once you have been a Supreme Court judge, your legal career is over. Okay, that is not the case for High Court judges. Why? Because High Court judges will not be allowed to practice in those courts where they have acted as a High Court judge. So let's say you are a High Court judge in the Madras High Court, and then you were transferred to, say, Patna High Court, and finally you became the Chief Justice of Sikkim High Court and retired. This would mean that you can practice law in all the High Courts except Madras High Court, Patna High Court, and Sikkim High Court. You can also practice in the Supreme Court because there you have not acted as a judge. So the High Court judges on retirement are not debarred from practicing in the Supreme Court. One is wrong. Number 2, violation of the Constitution is the only ground for the removal of High Court judge. High Court judges, Supreme Court judges have an exact same process of removal. And what is a removal ground? We know very well. The ground for removal is misbehavior, incapacity. So this is also wrong. Which of the statements is or are incorrect? Read these very carefully. Right answer is C, because both are incorrect. Next question. Which of the following statements regarding Article 142 of the Indian Constitution is incorrect? Again, a lot of incorrect today. It empowers the Supreme Court to exercise its jurisdiction and pass orders for doing complete justice in any case, any cause, any matter pending before it, including cases outside the ambit of law. And that's true actually. Article 142 provides Supreme Court with what we call an absolute power. This is, along with some other provisions, source of a very interesting concept called judicial activism, right? So along with Article 32, along with Article High Courts as well, 226, etc. This is what is a source of judicial activism for our superior courts. One is correct. The exercise of power under Article 142 by the Supreme Court is limited to the territorial boundaries of India and cannot extend to Indian citizens. No, that is a problem. It can still extend to Indian citizens residing abroad. Wrong. This is the right answer. Let's read the other two as well. Under Article 142, the Supreme Court can grant relief even if there is a statutory provision contradicting the relief granted, but it cannot legislate. Yes, of course. It can give its judgment on any matter pending before it to provide for complete justice. The idea is that Supreme Court wants to ensure complete justice, and in order to ensure complete justice, it can give any kind of order, right? So this is correct. And number 4, Supreme Court has utilized Article 142 to fill legal voids by providing guidelines in the absence of specific laws. I'll tell you an example. A very good example is Vishakha Guidelines, 1997. These guidelines were the only guidelines that existed to prevent sexual harassment against women at workplace. Finally, in 2013, a law was made by the Parliament. But for 16 long years, it was Supreme Court guidelines which were incorporated by every company, public or private, to prevent sexual harassment of women at workplace. So B is the wrong statement, hence the right answer. Next question. How many of the following statements accurately reflect the theoretical and conceptual framework of the judiciary's role in a democratic setup as envisioned by the Indian Constitution? The separation of powers doctrine forbids any retired member of the judiciary from being a member of either the legislature or the executive. Is that correct? Not as far as the Indian Constitution is concerned. Yes, we would love to have this, but sadly our retired judges can become MPs also. Yes or no? The 46th Chief Justice of India became the MP in the Rajya Sabha. They can also become governors. A more recent example would be S. Abdul Nazir, who became the governor of which state? Please tell me. So you can write in the comment section which state is he a governor of. S. Abdul Nazir. There was a case filed also in this regard, though people did not raise any concerns against his appointment, but they wanted Supreme Court to intervene in future such appointments. Supreme Court said it's not our concern. If some retired judge wants to take up any kind of post, it's totally up to him to see whether his taking up the post amounts to fairness or not. Anyway, that's the case. So one is wrong. Number 2, judicial review as a concept in the Indian legal system is limited to examining the constitutionality of legislative acts and does not extend to executive actions. No, see, judicial review in the Indian legal system extends to both legislative acts as well as executive action. The judiciary has the authority to review the constitutional validity of both, ensuring that both the organs adhere to the constitution. Maybe in some other countries that might not be the case. For example, in UK, the judicial review is limited only to executive action, not to legislative action. Parliamentary supremacy. So 2 is also wrong. Number 3, the principle of judicial independence is rooted in the idea of that judges must be able to perform their duties free of influence from legislative and executive branches as well as from private interest, of course. That is this entire principle of judicial independence is foundational to the functioning of democracy, ensuring that judges can make decisions based on the law and the constitution without undue influence from the other branches of the government or from any external pressure. 3 is correct. So how many of the statements accurately reflect the setup? So we know the answer. Only one, that is the third statement. A is the right answer. Next question. A judiciary that interprets laws in a manner that primarily benefits the government and its policies, thereby protecting their interests, breaches the principle of. If a judiciary tries to uphold the rules, regulations, policies of the government, even if those policies violate people's rights, infringes upon their rights, that judiciary is called a committed judiciary. Meaning what? Committed towards upholding government policies. Committed judiciary is a negative concept. It's not a nice thing. It's negative because if your if your performance is based on, or if you are performing just one task of upholding government's policies, come what may, whether they are right or wrong, I'm not sure how you are being effectively able to perform the role meant for you. So you are not committed towards upholding the values of the judicial system. No, you are committed towards upholding the government's values, which could also sometimes infringe upon rights of people. So if this happens, what is not happening? What is getting violated? Assertive judiciary is getting violated. Why? Because assertive judiciary means the judiciary which upholds the rights of people, come what may. So right answer is A. This concept is committed judiciary. And if we have a committed judiciary, what don't we have? We don't have assertive judiciary. It's a more positive concept. Right answer is A. See, integrated judiciary means lower court decisions can be challenged in the higher courts. Integration of the judiciary. And D again has no relationship to judiciary here at all. Competitive federalism simply means creating an environment of healthy, constructive competition amongst the smaller regional units called states, etc., for everyone's growth and development. A is the right answer. Next question. Which of the following statements accurately reflects the characteristics and functioning of a subordinate court or of subordinate courts in India? Okay. The establishment and the organization of subordinate courts are primarily governed by the provisions under Article 233. Yes, that's true. The subordinate courts have the jurisdiction to try both civil and criminal cases. Yes, we have the civil side, the criminal side, also called the what? Sessions Court. So 2 is correct. And number 3, the Chief Justice of the High Court concerned has the sole authority to appoint judges. No. Though the appointment is being done at the behest, on the recommendation of the High Court itself. High Court governs all the matters dealing with service conditions, etc. of the lower court judges. But officially, constitutionally, Article 233 says that the appointment is done by the governor. Okay. So on the advice of the High Court judge, the Chief Justice. So 3 is wrong. Select the correct answer. Answer is 1 and 2 only. A is the right answer. Next question. Consider the following assertion. Capital punishment passed by a trial court cannot be executed without the concurrence of the Supreme Court. Small error. Capital punishment passed by a trial, meaning lower court, district court, cannot be executed is correct without the concurrence of not the Supreme Court, but with the Supreme Court's permission be needed, High Court. Sufficient. So when the lower court gives a verdict of death sentence, let's say somebody does not appeal against the judgment, says, okay, I'll die peacefully, no problem. Even then, to execute the punishment, High Court's permission is required. High Court's, not Supreme Court. So assertion is wrong. We can get the answer directly. A is incorrect, R is correct. D is the right answer. But let's read the reason. India has a pyramidal integrated judicial structure that provides for control of the High Court over the subordinate one. Yes, of course, High Courts control all the lower courts which come under their jurisdiction. So R is correct. It's a factually correct statement. A is wrong. Okay, next question. Which of the following are the qualifications for a High Court judge? Qualifications for a High Court judge. Advocate in High Court for at least 5 years. Article 217, Clause 2 provides for this qualification. So sadly, advocate in High Court for 10 years. or judicial officer in the subordinate court for at least 10 years. Here also, judicial officer means judge in the lower judiciary. So this is also wrong, apart from this being wrong. Distinguished jurist, eminent jurist. Is this a qualification to become a High Court judge? No, this is a qualification to become a Supreme Court judge, not High Court judge. This is also wrong. All three are wrong. Right answer D, none. Next question. Consider the following statements regarding removal of Supreme Court judges. One more question on removal. A judge can be removed only by an order of the President based on a motion passed by both houses of the Parliament by a special majority. Absolutely correct. And what is a special majority? The same majority required to amend the Constitution. And what is that? 2/3 present and voting, more than 50% total strength, whichever is more, whichever is higher. When a removal motion signed by the members of Parliament is given to the presiding officer, he or she can refuse it. Yes, of course, as per the Judges Inquiry Act of the year 1968, if the MPs give a removal motion to or notice to the presiding officer, he has full right to reject it. Like in the case of Justice Deepak Mishra, when it was given by the Rajya Sabha MPs to the then VP Venkaiah Naidu, he rejected it. End of story. The committee that investigates into the charges against the judge consists of members of Parliament from both the houses. So the inquiry committee consists of judges, not MPs. It's like judges remove judges. Anyway, so the inquiry committee consists of the Chief Justice of India or any senior most Supreme Court judge, Chief Justice of one High Court, and also one eminent or distinguished jurist, maybe some retired Supreme Court judge possibly. So 3 is wrong. How many statements are correct? 2. B, only 2. Next question. While many states in India have their own high courts, few states share the jurisdiction of a common high court. Which among the following states have a common high court at Guwahati? Okay. See, Guwahati High Court was established in 1948 and served the northeastern states for a long period of time. However, there were certain states where a separate high court was established in 2013. Manipur, Meghalaya and Tripura. So, separate high court, separate high court, separate high court. And there was a law passed, the Northeastern Areas Reorganization Act, Amendment Act 2012. So, for them in 2013, separate high court, separate high court, separate high court. But for Assam, Arunachal, Mizoram and Nagaland, we have the Guwahati High Court, which serves the High Court for all these states. 1, 2, 5 and 6. D is the right answer. Okay. Next question. Consider the following statements with reference to the constitutional provisions related to the seat of the Supreme Court. Seat of Supreme Court. Where will the Supreme Court be established? So, this provision is found under Article 130. The Supreme Court shall sit in Delhi or any other place. Is that possible? Yes, of course. Supreme Court sits in Delhi. But if the CJI decides, then the Supreme Court can start sitting in Goa also. Enjoy the beaches of Goa and also provide judgments. So, 1 is correct. The seat of the Supreme Court shall be decided by the Chief Justice of India. Yes, of course. And number 3, the approval of Parliament is required before making any changes to the seat. No. With the prior permission of the President. Supreme Court can sit in any other place also, as a CJI decides with the prior permission of the Big Boss President, not the Parliament. we need the permission of the president. Okay, so 1 and 2 are right, 3 is wrong, 1 and 2. D is the right answer because it expects us to give us the correct ones. Correct. D. Okay. Next question. Consider the following statements with reference to tribunals in India. Tribunals, they are not bound by the Code of Civil Procedure. Yes, yes, of course. Tribunals have the advantage that they are free from these procedural shackles of, the Code of Civil Procedure, Indian Evidence Act, blah, blah, blah. They are free from all this nonsense. I mean, not nonsense, but free from these restraints, red tapeism, so as to say. That's there. So, yes. Unlike high courts, they do not have the power to punish for their, no, they do. The tribunals also have the power to punish for their contempt. Okay, so this is wrong. In India, the National Tribunals Commission takes care of the administrative and infrastructural needs of the tribunals. National Tribunals Commission. Have we heard of this body? Never. Why not? Because there is no such body. There is no such body called National Tribunals Commission, though this idea was originally mooted in 1997, the very famous L. Chandrakumar judgment. It is there that this idea came up that why don't we create a separate body which can take care of all the administrative needs of the tribunals, freeing it completely from the government's control. But as of now, the government provides or looks or takes care of all such needs. 3 is wrong, 2 is wrong. How many statements are correct? A. Only 1 is correct. Next. The Indian Constitution has provisions for the establishment of tribunals in the country. In this context, which of the following statement regarding the tribunals is not correct? Oh, not correct. Okay. There was no provision regarding creation of tribunals during the commencement of the Constitution. Yes or no? Yes. See, if you ask me, sir, was the word tribunal mentioned in the Constitution? Yes, it was. Article 136, Article 227. But that's it. How would we have tribunals? How will they be created? Who will create it? Nothing was mentioned. So 1 is correct. The provisions regarding tribunals were added by the Constitutional Amendment, that is the 42nd Amendment Act 1976. Yes, that's correct. It was added in 1976. 2 articles were added. Which 2 articles? 323A and 323B. These 2 articles were added. Okay. The State Administrative Tribunal, SAT. We have CAT, we have SAT. And in case it is required, we can have a JAT also. Joint. So, State Administrative Tribunals are established by the state legislature by law. This is actually wrong. Because administrative tribunals are to be established under Article 323A by Parliament by law. And that is why in 1985, the Rajiv Gandhi government passed a law called the Administrative Tribunals Act, providing for CAT for central government employees and SAT in each state for the state government employees. So SAT has been created or established by the Parliament, not the state legislature. C is wrong, hence the right answer. And awards of NGT can be challenged only in the Supreme Court. Yes, that's very interesting. See, awards of tribunals can be challenged. Originally, it could be challenged only in the Supreme Court. But in 1997, the L. Chandrakumar case, Supreme Court said, how dare you bypass the High Court? High courts are also court of records. They are also constitutional courts. They also have a writ jurisdiction. Don't dare to bypass high courts. So from that day onwards, tribunals awards were all challenged in the high courts first. Then in the Supreme Court, it's mandatory. But then what happened? NGT Act was passed under the provisions of 323B by the Parliament in 2010. And the NGT Act says that the award of NGT can be challenged only in the Supreme Court. So that still remains. Hence, D is also correct. Next question. Consider the following statements regarding Central Administrative Tribunal, CAT. The provisions of tribunals were added to the constitution based on the recommendation of the Swan Singh Committee. Yes, that's true. Sardar Swan Singh also had a very interesting distinction of being the longest serving cabinet minister, various ministries. On his recommendation, we have had two things added in the constitution. One is part 14A. And what is that? Tribunals. Of course, one is correct. What is the other one? What is the other provision that was added in the recommendation of Sardar Swan Singh Committee? Please write in the comments, we'll see whether you know it or not. It's also a very unique part, very interesting part, inspired by the concept that they had in Soviet Union. Anyway, so yes, one is correct. Number two, it is a part of the basic structure of the constitution that the high courts have power to exercise judicial supervision and charge over the decisions of all courts and tribunals within their jurisdiction. Yes, of course, that's absolutely correct. In fact, Article 227 says the same thing. L. Chandra Kumar also suggests the same thing of 1997. 2 is correct. Number 3. The CAT is empowered to frame its own rules of procedure and practice is also correct. And the decisions of CAT can be challenged only before the Supreme Court by filing SLP, special leave petition. Sadly, no. Decisions of CAT will be challenged where? So, CAT first appeal goes to High Court and final appeal goes to the big boss Mahamahim Supreme Court, the apex court of the country. So 4 is wrong. How many statements are correct? 3 statements are correct. Okay. C is the right answer. Moving on, if the President wants to seek legal opinion on a matter of public importance from the Supreme Court, then what happens? President wants to seek a legal opinion. This is the very famous advisory jurisdiction of the Supreme Court. Article 143. Now, just a small point. Whenever the President wants to seek opinion of the Supreme Court must give its opinion in an open court. Open court, right? Not in the closed chambers. Open court does not mean some garden. In the regular court where everybody is there. And number 2, this advisory jurisdiction has to come from a 5-judge bench, minimum 5-judge bench, not less than that. So a constitutional bench, and this is mentioned in the Constitution also, Article 145, Clause 3. Anyway, so what happens then? Supreme Court can assume to itself the power of the legislation. Nonsense. How can Supreme Court assume the power of legislation? No. The President has to accept the advice given by the court. No, it's an advice. The President may or may not accept the advice, right? Like we give the advice, please study, please revise, but you don't, or you may or may not follow the advice. Same thing. Then Supreme Court may refuse to tender its opinion. Yes? Yes. See, there are two things. Number 1, if the President seeks opinion on any general matter of public importance, then the Supreme Court can say, no, we are not free. Please, you want to know our opinion, you file a case in the court. In that case. But if the President wants the Supreme Court to give an opinion on interpretation of laws, then the Supreme Court must give its opinion. Difference. So here, Supreme Court may refuse to tender its opinion. Absolutely correct. Yes, not binding. Then President has to first get the approval of the Parliament for the same. Nonsense, no need for the parliamentary approval. This is basically the government wanting to know before actually filing a case in the court about whether that case is worthy of standing in the court of law or not. See, because at every point of time when the government tries to file a case in the court, you are wasting taxpayers' money, right? Because you are hiring these lawyers who are called the additional SGs or the Solicitor Generals or the Attorney General of India, paying them a daily fees. So if people file a case, it's okay, but you should not be filing cases uselessly. that is also one reason why this is being used. Okay, so C is the right answer. Next question. Which one of the following is directly related to the appellate jurisdiction of the Supreme Court of India? Appellate jurisdiction. What is appellate? By way of appeal. Appeal, right? Not direct. Direct means what? Direct and exclusive. So just to give you a point here, Article 131 provides for original jurisdiction of the Supreme Court, which is direct as well as exclusive. What is direct and exclusive? You can directly go to the Supreme Court and you can go only to the Supreme Court. Okay. So one such example would be any federal dispute. What is a federal dispute? Dispute between center or states, or state versus state, like Kerala filed a case, West Bengal filed a case against center, etc. That's a federal dispute. You directly go to Supreme Court. Please tell me what is the other example of a dispute where you can file a case only in the Supreme Court and you can file a case directly in the Supreme Court. Direct and exclusive. Please write in the comments this also. Let's see how many of you know this, how many of you are revising properly. This is one thing. Now, just to clarify, fundamental rights, to protect them, the courts can issue writs. Writs means orders. Mind you, writs are not original jurisdiction. Why? Because yes, you can directly approach the Supreme Court asking Supreme Court issue order, writ. But it's not exclusive. You can also approach the High Courts. So writ jurisdiction is shared between Supreme Court and High Courts. Hence, please don't write fundamental rights in your answer, or that would be wrong. Okay. Anyway, let's come back here. So as I said, appellate meaning by way of appeal. So one type of matter is a matter which goes directly in the Supreme Court, and then most other matters come to the Supreme Court by way of appeal, starting in the maybe lower court, coming to the High Court, and then to the Supreme Court. What kind of matters? Appeals made in the civil cases. Yes, Article 133. Criminal cases, yes, Article 134. Constitutional cases, Article 132. A is the right answer. Appeals made in such cases only, no. In civil and criminal also you can go to Supreme Court. This is wrong. Adjudication of dispute between center and states or between the two states. These two are examples of original jurisdiction. Article 131. Directly in the Supreme Court, not by way of appeal. Just to clarify, if there is any issue between UT and the center, then this matter would go to High Courts. Okay? Not to Supreme Court, because UT, as the name suggests, is what? Territory controlled by Union. High Court, Supreme Court. Then, which of the following statements is or are correct regarding Lok Adalats, People's Court, Lok Adalats? Once a litigant has approached the Lok Adalat for the settlement or compromise, he or she cannot go back to the court. Is that the case? See, the beauty of Lok Adalat is that it is based on compromise, right? Compromise. Two parties agree and settle the dispute peacefully, amicably. So, let us say somebody, or let's say a bank wants to get its loan back. You are a shameless defaulter who has been absconding, not giving the money back. Bank has filed a case in the court against you. Now we know very well how quick and fast the judgments come in the court, right? So that's there. So the bank realizes that, it's taking too much time in the court. Let me ask that fellow, do you want to solve the problem? Are you happy giving me at least some money? I'll take back the case in court. And if you agree, end of story. So while a court case is still pending, the bank can approach the Lok Adalat to resolve it. Or the bank can firstly ask you, hello shameless fellow, are you willing to pay at least 50% amount? If you say no, the bank can go to court. So Lok Adalats are available in the pre as well as the post litigative stage. Okay, any stage. It is not that once a court case is filed, we can never approach the Lok Adalat. That's not the case. So this is wrong. And see, if the bank has gone to the court and filed a case, and let's say you refuse to compromise, no problem, the bank can still go to the court. The court is always open. The doors of court are always open for the institutions. They just want to try whether that fellow wants peaceful settlement of disputes or not. Its decision is deemed to be a decree of a civil court and it deals in matters related to civil cases only. This is wrong. Lok Adalats also deal with petty criminal cases called compoundable criminal cases also. And number 3, an award made by the Lok Adalat is final and binding on all the parties and no appeal lies before any court against it. Is that correct? Yes, of course. An award made by the Lok Adalat is final, it's binding on all the parties, right? Now you may say, sir, how is it possible? Can we not appeal against the award in Supreme Court? Possible? Supreme Court? Not possible. Because Lok Adalat is not giving a judgment per se, it's just effecting a compromise. Somebody asks you, you have taken 100 rupees from me, please pay me 50 rupees, end of story. If you agree, compromise. If you don't agree, the person will go to the regular courts, file Lok Adalat. So you cannot question why 50 rupees, no, give me a discount, I'll pay only 40 rupees. That cannot be a question. It's a compromise. Okay. So 3 is correct. How many statements are correct? We know very well. Only one statement is sadly correct. A. One only. Next. Consider the following statements. The Supreme Court can sit only in Delhi. We just saw it. Article 130. Supreme Court can sit only in Delhi or any other place also. This is wrong. Number 2. The High Court of a state should necessarily be situated only in the state capital. Not really. In fact, lot of high courts are not in the state capitals. In fact, their principal bench is in a different city in the state. Say Allahabad High Court, Jodhpur High Court. They might have one bench at Jaipur or Lucknow, but the principal bench is not in the state capital. That's not mandatory. And number 3, northeastern states have only one high court at Guwahati. That's not correct. Though lot of at least 4 states are being served by the Guwahati High Court, but states like Manipur, states like Tripura, states like Meghalaya, they all have their own high courts. So 3 is also wrong. Which of the statements given above is or are not correct? D. All are not correct. Next question. Which of the following statements is not correct? We have not a lot of not corrects. Not corrects also gives you the advantage of knowing what is correct. That's so. Okay. Not correct about the Gram Nyayalaya Act 2008. Gram Nyayalaya. It aims to provide inexpensive justice to people in the rural areas at their doorsteps. That's true. That's the principal objective. Now, when I say doorstep, please don't feel that the judge comes knocking on your door. Hello, sir, justice, anyone, justice? That's not the case. But regular courts are held at the local area where the Gram Nyayalaya is to be established for every panchayat at intermediate level. Yes, that's true. Or for a few more villages or for a few villages also. So Gram Nyayalaya does not mean village, a court at every village level. No. It means court in every intermediate level of panchayat. Okay. See, the act shall not be applicable to 5th and 6th schedule areas. Yes and no. This act is not applicable to 6th schedule areas, but it is applicable to 5th schedule areas. In fact, beyond this, the Gram Nyayalaya Act is not applicable to 6th schedule areas. Also, states like Arunachal, states like Sikkim, and states like Nagaland. So C is incorrect, hence the right answer. And D, The Gram Nyayalayas will also try certain criminal cases in addition to civil cases. Yes, they can provide for jail punishments also, up to 2 years jail, or fine up to how much? 20,000 rupees. Okay, that's that. So D is also correct. C is the right answer. Not correct. Next question. In order to be appointed as a judge of the higher judiciary, that is Supreme Court or High Courts, a person should be a citizen of India and must possess other qualifications. Of course. In this context, which of the following statements is or are correct? An advocate having more than 10 years of practice in a high court or 2 or more such courts in succession can be appointed as judge of either Supreme Court or the High Court. Yes or no? Yes, of course. Right? So this is correct. See, the qualification for Supreme Court and for High Court. Supreme Court, you have to be a judge for 5 years in a High Court. For High Court, you have to be a judge at a lower level for 10 years. That is for a judge. And for advocates, you have to be an advocate 10 years in any High Court, 10 years in any High Court. So that is there. Beyond that, there is one more qualification for Supreme Court judges. And what is that? Let's see. A person who is a distinguished jurist in the opinion of the president can be appointed as a judge of either the Supreme Court or the High Court. Sorry, this jurist concept is available only for Supreme Court, not for High Courts. This is wrong. 2 is wrong. Right answer A1 only. Okay, always remember the jurist qualification is meant only for the Supreme Court, not for the High Courts. Next question. Consider the following statements about Nari Adalats in India. They are women-only courts that address individual cases and raise awareness about social schemes. They do not hold any legal status and are primarily focused on reconciliation, grievance redressal, and also creating awareness about the rights and entitlements of women in the country. And number 3, it is an initiative of the Ministry of Women and Child Development under the Sambal sub-scheme of what? Mission Shakti. Actually, all these statements are correct. How many statements are incorrect? None. All these 3 are correct. So this is some information for you about Nari Adalats in the country. Okay. Next question. Consider the following statements regarding justice clocks recently seen in news. Justice clocks. Interesting. These are clocks installed across all subordinate courts, showcasing the time taken by the judge to dispose of cases. So we know that there's been an increasing pendency in the Supreme Court, and because of that we need to bring down the pendency of the Supreme Court cases. There's a bigger pendency in the High Courts. We have to bring that down, and even bigger pendency in the subordinate courts. 4.4 crore cases are pending in the lower courts itself. So possibly for that, let's see. It's an initiative of the NALSA to ensure that citizens are made aware of the pendency of cases in the country, and the project has been funded by contributions from both the public and private sector. How many of the above statements are correct? All of them are wrong. Okay. That is not what justice clocks are. Justice clocks recently have been installed at the court complexes in our high courts firstly. So all the 25 high courts have seen the installation of 39 such justice clocks. And what are they? These are LED display boards, not some clock per se. LED display boards that serve as an electronic signage system. So the primary function is to effectively utilize the database from the National Judicial Data Grid. All information from there, by making information accessible to public, making people aware about the court's information and details, right? And this initiative has been spearheaded by not NALSA but by the Ministry of Law and Justice, funded by the government. And what is the aim? Enhancing public awareness about the justice sector eventually. So it highlights various departmental schemes, provides updates on the status of diverse initiatives taken by the courts, etc. That is the point of digital justice clocks. Not that a clock has been put in the courts. Anyway, so how many statements are correct? We know the right answer. None of the statements were correct. So please follow, because sometimes the UPSC might ask you a one word question on that. So we should know what that topic is. Maybe not in so much of detail, but basic information is something that we should be aware of. Okay, next. Consider the following statements about legal procedures in India. So, legal procedures in India. Number one, police officers can arrest individuals without a warrant for cognizable offenses. Is that correct? See, cognizable and non-cognizable offenses are classified under the CRPC 1973. At least till the new BNS and BNSS are not applicable, we will follow CRPC. So in cases of cognizable offenses, police officers can arrest the accused without a warrant. Yes. And they can also initiate an investigation without the court's permission. That is what is a cognizable offense, right? And these offenses must, they typically include serious cases, murders, rapes, thefts, and FIR must be registered for all cognizable offenses under section 154 of the same CRPC. And the police can also conduct preliminary inquiry before doing so. By the way, the accused must be presented before the magistrate within a specified period, and due to the severity of the crimes, court approval is implicitly granted. Okay, so court's approval is there, is what is the implied sense. Hence, arrest without warrant. Correct. Now, in contrast, a non-cognizable offense, it does not allow the police officer to arrest without a warrant or even start an investigation without judicial approval. So these are generally bailable offenses without any, or they involve lesser crimes, defamation, forgery, etc. Though both bailable and non-bailable categories can include cognizable offenses, but sometimes it would depend. A bail might not be given depending on, number one, judicial interpretation, and also how severe the crime is. Okay, so that's there for cognizable, but yes, non-cognizable offenses are generally bailable, small petty offenses. Think of it like this: non-cognizable, relatively smaller offenses; cognizable, more serious ones, and hence the classifying difference is that arrest without warrant is possible. Here, it's not possible. So both the statements are correct. They, reflect the accurate and distinct legal processes for each category of offenses under CRPC. Right answer is C, both 1 and 2. Okay, next question. Justice Geeta Mittal Committee, recently news was set up to Justice Geeta Mittal Committee supervise, intervene and monitor relief, rehabilitation and restoration in Manipur, recommend the criteria for providing reservation to OBCs in the legislatures, suggest steps to be taken to increase the number of seats of IAS per year. Currently, it's only 180 IAS officers being hired every year. And D, look into the demand for including Ladakh in Schedule 6. So, very tragic incident happened on 3rd of May 2023, that is last year, almost a year back. Violent ethnic clashes erupted in Manipur between the Methi people in the Imphal Valley and the Kuki-Zo tribal community from the surrounding hill areas. And the catalyst for this violence was a tribal solidarity march protesting the Methi community's demand for scheduled tribe status. In fact, the Manipur High Court's order, which directed the state government to recommend ST status within, I think, May 29th, further intensified the tensions. And in response to the escalating situation, the Supreme Court appointed a 3-member committee led by the former Jammu and Kashmir High Court's Chief Justice, Justice Geeta Mittal. And this was appointed, I believe, in August 2023. And the committee was constituted by the Apex Court to, of course, intervene and monitor the relief and rehabilitation, restoration of homesteads, religious places of worship, etc. in Manipur. And in fact, the Chief Justice had said also, Justice Chanchud, that the committee through its work would endeavor to reinstill in the people of Manipur this belief in the rule of law, that there is somebody who's there who will ensure that your lives will be back on track. And that was the purpose of Justice Geeta Mittal committee. So right answer is A. Okay. Next question, which of the following statements most accurately describes Article 136 of the Indian Constitution? It allows the President to seek Supreme Court's advisory opinion on legal questions. What is this article? 143, advisory jurisdiction. It grants the Supreme Court special leave to appeal against any judgment in any matter from any court or tribunal. This is Article 136. So, yes, right answer, Article 136, special leave petition. Let's see the other option also. It designates the Supreme Court of India as a court of record with all the powers of such a court. Court of records for Supreme Court is Article 129. So, of course, is wrong. And D, it states that the law declared by the Supreme Court is binding on all the courts within the territory of India. This is Article 141. Articles pertaining to Supreme Court are slightly more important. Maybe not the number per se, though we have seen a question being asked directly from Article 142. But again, the options were such that even if you knew within what part Article 142 lies, you could answer the question. But still, we should know, at least for judiciary, the contents of the articles also. No need to mug up verbatim. Just roughly know what article contains what provision. That could be of great help in case a question like this is asked. Consider the following statements about Lok Adalats in India. One more question on Lok Adalats. Okay. So, the decisions rendered by Lok Adalats are final and binding on all parties involved, and no appeal lies against such decisions in any court. I think we have discussed this just now. Please always remember the decisions are binding. Yes, no appeal. Correct. Lok Adalats are organized by the NALSA under the Legal Services Authorities Act 1987. Yes, we have the concept of permanent Lok Adalats established 2002. And the permanent Lok Adalat comprises of one chairperson who is a judicial member, normally usually a district court judge or a retired district court judge or anybody who is above the post of additional district court judge. And we have two other members. These two members are non-judicial members who normally are experts in that particular public utility service to which that Lok Adalat is established for. Number 3, every award made by Lok Adalat is deemed to be a decree of the civil court. Yes, that's true. Every award made by Lok Adalat is deemed to be a decree of the civil court. And let me just clarify one more point. The jurisdiction of Lok Adalats is up to 1 crore rupees. 1 crore. This is as per the NALSA website. I'm not sure whether books would have this update or not, but always remember, Lok Adalats can settle disputes amounting to a value of maximum 1 crore rupees. Anyway, so 1, 2 and 3 all are correct. How many statements are incorrect? None of the statements are incorrect. D is the right answer. Consider the following statements about legal procedures in India. One more question. This time it's compoundable. Okay, so in compoundable offenses, the complainant can agree to a compromise with the accused. In compoundable offenses. So see, a compoundable offense allows the complainant to compromise. The idea is compromise. Okay. So allows the complainant to compromise and withdraw the case against the accused. This also is outlined in section 320 of the CRPC, which contains list of all the offenses which can be settled outside the court. Non-compoundable offenses, on the other hand, they are ones which cannot be settled outside through compromise because of their serious nature. and these offenses can only be quashed by judiciary, not compounded, as they are not listed in section 320. And these include more severe criminal acts and hence require a full legal process. No out of court settlement. In short, out of court settlement is not allowed in case of a non-compoundable offense. In case of a compoundable offense, it is allowed. Chain snatching, pickpocketing, maybe too tight slap from the police, come on, give the money back, get lost. Or in your college days, two groups are fighting to impress some random third person who has no idea that you guys are fighting for him or her. The police comes, calls the gang leader, slaps both of them, come on, shake hands, get lost, end of story. They won't file a case against you, spoiling your career, etc. Compoundable offenses. In fact, Lok Adalats also settle compoundable criminal cases, petty offenses. So yes, it is correct. Compromise is possible, and in the non-compoundable ones, no compromise. You murder somebody and say sorry. No, that's not possible. Full legal process has to follow. So which of the statements are correct? C, both 1 and 2. Consider the following statements about High Court judges in India. The age of retirement of High Court judges was 60 at the commencement of the Constitution. 60 really? So as of now, the High Court judges retire at the age of 62. For the Supreme Court, it is how much? 65. Now originally, the High Court judges would retire at the age of 60. This is correct. It was only in 1963, 15th Amendment Act of the year 1963 that the retirement age of High Court judges was made from 62 or increased to 62 years, the age of superannuation. Number 2, the minimum age to become judge of High Court was 50 years, which was repealed by the 40s. Nonsense. There is no such minimum age which was repealed and all. Nothing of this sort. So we do not have any minimum age for our judges, but we have a maximum age for our judges. Plus, there is no tenure. Your tenure will depend on when you entered the High Court or when you entered the Supreme Court, right? For how long will you serve? It depends on your entry. If you entered the age of 55 in the Supreme Court, you serve for 10 years. If you entered the age of 60, you serve for 5 years, right? Unlike in some countries like say USA, you'll be surprised to know that in USA, there is no retirement age of judges. There have been examples where judges have passed away while writing judgments. So old, 87 years old. Anyway, so 1 is right, 2 is wrong. Which of the statements is or are correct? We know A1 only. Okay. That's it guys for today. So again, we have covered a lot of ground on judiciary. My advice would be I have written some articles, right? Just go through them and read the articles on your own. It's important not to mug up the content. You already know the content in brief. Just have to correlate so that if a question is asked, we know it firstly. And number 2, selective revision. If you have missed out on any option, and also let's say you find the right answer, as I say always, even if you end up finding the right answer, please verify that you know all the options. Okay. So if at all you have missed out on some question or don't know some of the options, please go and selectively revise. Selective revision is very important. Focus on that. Okay. That's going to be it. Tomorrow we'll have day 4, session 4 of Polity Target Prelims, which means what? We'll be covering questions from topics like fundamental rights, DPSPs, fundamental duties, topics like preamble, etc. Interesting topics. You normally have questions from these topics. A lot of questions are asked from these topics, right? So please revise accordingly, and we'll meet tomorrow. Till then, that's all for me. Jai Hind.